Welcome back to Media7. Defamation law exists to ensure that reputations are not unfairly tarnished. But is that law being used to stifle debate about things we, the public, need to know and to limit free speech? Late in May, an 11-month defamation action taken against writer and researcher Nicky Hager by Linton Crosby, co-founder of Australia-based political consultancy Crosby Textor, concluded in a settlement. We invited Linton Crosby on this program to discuss the action. Instead, we got the following letter.
Mr Crosby declines the invitation to appear on the Media7 program. We request that Media7 provide to us a written undertaking that it shall not broadcast or republish the defamatory material in Mr Hager's blog or any other material defamatory of our clients. In the event that the defamatory material is broadcast, we anticipate receiving immediate instructions to commence proceedings in relation to the same. We note that this letter is not for publication.
So, the material facts of that dispute will not be talked about here, but we are interested in the wider matter of whether defamation law can be used to silence reasonable expression. Joining us, we have Associate Professor of the Canterbury Law School, Ursula Chair, and Nicky Hager, Investigative Reporter. Thank you for joining us.
Hi, Simon.
Now, if we can start first with you, Ursula, let's get a definition of what defamation law is. What is defamation?
Okay, well, a defamatory statement is basically a false statement about a person to their discredit, so it affects their reputation in a negative way.
And how can someone make such a statement?
You can make it almost any way. You can speak it, you're publishing it then. You can write an article, talk on television, on the radio, on the internet. So the forms of publication are varied, basically.
And does it have to be a bald-faced statement, or can it be implied through things you say?
No, obviously any meaning can come from a literal meaning, what the words actually say, or it can be an imputation or an inference that ordinary people would draw from the statement.
And are there any defences? That seems very broad.
It's extremely broad. Yes, thank goodness there are defences. The most obvious one is truth. So if you're able to establish the truth of what you say on a balance of probabilities, that's not necessarily an easy thing, especially, you know, in a court case. Honest opinion is another very valuable defence. Obviously, freedom of expression is very much bound up in that. And now we've got a kind of developing public interest defence, which is very useful, and that actually allows for mistakes, whereas usually mistake is not a defence in defamation.
And so the way things currently are, is the system, could it be seen to be pro-claimant or pro-media and people who are making statements?
Yes, the system has very definitely been seen as pro-plaintiff, pro-claimant, in that all they have to do is show that the words were defamatory, that they were spoken about the person and that they were published, and then the onus goes on the defendant to make out those defences. So there's all the pressure kind of goes to that point on the defendant.
And no matter the merit of the complaint, that person then has to get a lawyer, go to court, prove on the balance of probabilities that what they said was reasonable for some reason.
There's nothing actually requiring that. I mean, many matters are settled in a very informal way. The media gets very low-level complaints all the time that may or may not threaten an actual court case. So that's a matter of talking to the person, finding out what went wrong, perhaps publishing a little correction in your correction column in the newspaper or whatever. So many complaints go away being dealt with in that informal way. But if you have a statement of claim filed, actual proceedings filed, then you're on a roller coaster and you have to take part in that process and meet the time limits that are required and so on, and that can be kind of breathtaking in a way.
Now, Nicky, although we're not talking about the case that has just concluded, have you as an investigative journalist had letters from people?
Yes, of course. I've had various letters over many years from people who think I've got something wrong or who think I've defamed them. In most cases, someone feels angry about something that happens, they send the letter off, but nothing happens afterwards. That's the normal thing. I'd say 90-something%, the high 90% of cases there's a threat made or an expression of unhappiness, and that's the last you hear of it. And of course, sometimes the people might be right. And if you're in my position, the first thing you want to do is to carefully check what you did, and maybe you've made a mistake. And in that case, there's a very simple remedy, which is that you try to correct it as fast as you can.
And so is this quite a common occurrence?
For me, I've once corrected something back in the 90s that I can remember. But yes, that's quite common, that somebody will see they've made a mistake and they will move quickly to correct it. And that's normally the end of the matter, yeah.
The way the law currently is, do you think that it could be used to help to stifle debate?
Yes. In most cases,
what is it about the law that allows this to happen?
Well, let's be fair. For a start, people should have some remedy if they get defamed, and we don't want to deny that. I personally get defamed quite often, but I can't afford to take it myself. But I can see that there's a place for it. What can happen is not that somebody is seeking to have something corrected, but simply that they're angry at you for what you did, or that they don't want an issue to be publicised. And this has been raised, for example, in the recent months by the British media. They feel it's gone too far there, where if you get a very serious set of legal threats against you and proceedings started, then you can be seen to be aggravating an issue if you continue to publicise it. And that's quite an effective way of closing down something which someone doesn't want to have publicised. And so even if the case doesn't have merit, even if eventually when it came to court nothing would happen, if you've got a great big legal battle suddenly rolling out, as was happening in these British cases, it has a chilling effect on what goes on. And there's even a worse part of it than that, which I think is the main area where defamation works, because I watched it from the inside of the media, is it never comes to the story being published. It never comes to the letters arriving, because there are certain kinds of people who it's easier not to write about. If you're writing about...
It's a self-censorship ahead of the fact.
I think that one of the main effects of defamation, you never see it because it's self-censorship at the level of the editor and the chief reporter thinking, what, we don't need trouble over this.
What is it a fear of? Is it a fear of costly legal proceedings, or is it a fear of damages?
Even when it's honest opinion or the truth, if you aggravate somebody who's got the resources to take a court case, you can suddenly find that instead of doing your job, you're spending an awful lot of time talking to lawyers and preparing papers and preparing endless evidence which will never be used, but where you have to do it because the process is grinded out of you. And if that's the situation, it's actually easier not to bother. And so I think you can actually see it partly. There's not very much restraint about stories about poor people and prisoners and criminals and people like that, because they're not very likely to sue for defamation and they don't have the resources to do it. And there are certain classes of citizens who, unless it's extremely watertight and you might have had to push very hard, it's easier not to run the equivalent story.
What would your take on that be, Ursula? Do you think that there is that level of self-censorship perhaps happening?
I think there may well be a level of self-censorship. Certainly in the UK, there's been studies in which the media have said that. I did my own study of New Zealand media back here in 2001. I found on the whole that we had a pretty robust media, and most of them were telling me that we do manage to get stories told. It did require talking to lawyers on occasion, but they were also quite good at knowing what to leave out in it. But they did actually get those stories out there that they wanted to be told. So I concluded in the end that there wasn't a significant chilling effect that we needed to be too worried about. But what Nicky, I think, is talking about is the situation where you've got people who are not actually media and therefore as well resourced, but they're behaving in a media-like way. So they're breaking stories that have high public interest. Now, there you've got an inequality, and so the defamation laws can be used by a plaintiff who is well-resourced to try and shut down folk who aren't well-resourced and who perhaps haven't got a lawyer who can work pro bono for them or something of that kind.
Well, you've had to engage pro bono representation of us. I mean, what kind of costs does it involve to fight a case like this if you don't have pro bono representation?
If you didn't have a free lawyer, you could be spending tens of thousands of dollars, and it could go up, and if you lost over a technicality, or if you got... What can happen in a court case is not that you have lost on the issues, but you have been ground down by the process, and the cost from here to the possible conclusion is so great that you have to bail out, and you end up paying the other side's costs or something. And so somebody who goes into one of these processes can lose an enormous amount of money, which is why, unless you've got a free lawyer like I'm lucky enough to, you would settle, possibly in an embarrassing, humiliating way, early on rather than spend all that money, because you don't have any other exit point.
Well, in some ways, a lot of this is very hard to quantify because these stories don't make it if they have been stopped. But are there international examples that we can go to?
Yes, definitely. Probably a very well-known one is the McLibel case that involved McDonald's pursuing two impecunious anarchists who distributed leaflets outside McDonald's in London, and that case dragged on for well over a year. The two anarchists had to represent themselves, although they had a little bit of free help. So there in the end McDonald's won. Basically they won the battle, and there were damages against the two of them up to £60,000, which is not actually a very high award comparatively. They simply said we haven't got the money to pay. So in the end McDonald's won the battle but lost the war. McDonald's spent millions fighting that case, weren't able to shut the anarchists down. Actually there was a website set up, the McLibel website, the whole thing was out there. So in a way, McDonald's actually helped to turn the thing into a great deal of publicity for what these two anarchists were trying to get across. So there you had an attempt to shut down folk, not media, but behaving in a media-like way. And you could say literally they did shut them down, but no, maybe at the end they didn't.
I'd like to go a bit further than that though, because even in New Zealand, lest we think there isn't a problem, I have been involved in things where when it has come to it, I'm talking about across various news organisations, where it's come to it, it's been easier not to do the story. That I've felt it, it's been pretty apparent to everyone involved that if it was somebody less important, less litigious, less wealthy, that it would just be a story that they would like to have, and it's easier just not to go there.
Well, so what could be done to change the way defamation law works so that wouldn't be so easy to happen?
Well, I think that Ursula can answer this way better than I can, but can I make a general comment?
You have started the discussions along this, haven't
What
you?
you want is that it's the substance of the claim, because someone might have been defamed, and that's fair enough that they have a remedy for it. But you want the substance of the matter rather than the process to be how people win. Because if it's the process, it means that the person with the most resources and the most staying power and the most bloody-mindedness and punishing mood may well win simply because they've got the most resources, that they can drag it out or they can extract a cost from their opponent even when they don't have the right on their side. How do you solve that? I personally think, from my experience and the things that I've read, that the current defamation laws don't work. They are too based, they are extremely circuitous. You can't actually establish the rights and wrongs till the very end of a very long process.
And that's
often.
When you get to court, is it?
Yes, which hardly anyone ever does, as it happens.
And in the meantime, there's a lot of billable hours. There's a lot of...
The meter has been running on every party involved in it, and so the richer ones are going to have the most staying power. So I would argue you need a new system. You need a new system from the ground up, or it won't work.
What do you say to that, Ursula?
Yeah, I think Nicky is focusing, really what you're talking about are procedures. There's no doubt that defamation law is highly technical. It requires lawyers who are specialists, and lawyers don't charge small amounts. So there's no doubt that the law could generally be simplified. I think the basic principles are right, and that must be so if you're going to say it is all right for a person to want to protect their reputation if they need to. So the processes could be made more simple. And I mean, they've worried about this in England for years. They've looked at it here periodically. One thing, a more major thing that could be done would be to adopt the requirement that they have in America, which is that a plaintiff has to show not only that the words are defamatory, but that the defendant was motivated by malice. So there was ill will in publishing.
And so just by adding that would change a lot,
it would
wouldn't
certainly take a lot more pressure off the defendant and put much more on the plaintiff. And, that's constantly being held up as desirable. The media here have often suggested that. The alternative, or an alternative, is to look for a much simpler procedure. So perhaps a low-level complaints procedure where media or, all parties could go to, which would be cheaper, more accessible. The focus would be not on money, but on corrections.
Fast resolution.
Exactly, fast resolution. So it's something like the disputes tribunal, but just for perhaps matters of reputation. And certainly when I did my study in 2001, that was something that the media suggested, and they were quite keen on that. But folk like Nicky would benefit from it as well.
And are there any moves moves afoot to make these changes?
Defamation law has not been looked at for years. I mean, the last act and the last revamp was 1992. There's been no great pressure, as far as I'm aware, to change it.
Well, thank you, Ursula Chair and Nicky Hager, for coming on to talk about what is quite a difficult discussion. After the break, we're going to be going to Iran to see the impact that new media are having on traditional reporting.